The way the system works is that after each side picks a bunch of jurors, each side is allowed to dismiss many of the jurors that were selected by the opposing side. One problem is that the winning attorneys might have more money to spend on jury consultants. Jury consultants are highly paid experts who use psychological analysis on each potential jurist to determine if he maintains any unfavorable biases and prejudices so that a biased jurist can be dismissed. On the other hand, if a potential jurist's prejudices are favorable to their client, that juror will be chosen to serve on the jury, unless the opposing side detects those prejudices, in which case that juror will likely be dismissed. A jury consultant will scrutinize a potential jurist's age, race, religion, gender, hairstyle, and clothes. The jury consultants might employ handwriting analysis, body language analysis, and a plethora of other techniques to effectively discern and detect a juror's thought processes and his likely biases. The jury consultant might also have each juror fill out extensive questionnaires that are then meticulously scrutinized by their team of expert psychologists, so that by the time they are done evaluating a juror, the consultant knows with a fairly high degree of certainty what each juror will likely conclude upon hearing all of the evidence in a trial, what evidentiary details that juror is predisposed to overlook or ignore, and what evidentiary details a potential juror is predisposed to be responsive to emotionally. While any run-of-the-mill jury consultant can identify the most effusively supportive or blatantly antagonistic jurors, there are rare cases of consultants with psychological intuitions that are so advanced above the norm that they can identify prejudicial leanings that are completely imperceptible to the amateurs on the losing side of the courtroom. So naive and bumbling are the losing attorneys that I will compare them to Atticus Finch, that lawyer who never won a case in the book most of us had to read in high school, called To Kill a Mockingbird. The losing attorneys, who are blind to subtle clues of juror prejudices, will naively designate certain of the shark attorneys' jurist picks as unbiased, and will carelessly waive their prerogative to dismiss those detrimental jurors from serving on what might otherwise have been a fair-minded or even favorably biased jury. During a jury selection, the Atticus Finch type attorneys might heedlessly take every answer from the jurors' questionnaires at face value, and then pick jurors based upon the most crude and obvious statistical stereotypes, as if every white, black, minority, female, or aged juror maintains the prevalent mindsets for his respective groups. But as we all know, not all women are feminists, and in fact most probably are not. And not all blacks are liberal Democrats who are opposed to owning guns. And not all of the elderly are staunch conservatives. For he is well aware that he alone among attorneys can divine the jurors' hidden weaknesses of character. So even if the rank amateur Atticus Finch type attorney succeeds in nominating exclusively sympathetic jurors, the insidious shark attorneys can foil their efforts by sifting through their picks and summarily dismissing all who are virtuous and dedicated to justice, while retaining the malleable ones. The shark attorney knows that the juror whose loyalty to justice is a mile wide but only an inch deep will be prone to reversing allegiances once exposed to the rapid-fire arguments from the quick-thinking, well-read, shark-ratified jurists in the deliberation room. One famous example of this phenomenon, where unequally matched attorneys were pitted against each other in the courtroom, was in the O.J. Simpson trial, where virtually all of Prosecutor Marcia Clark's carefully screened jurors confounded the world by voting against her side in the final verdict, in spite of the abundance of evidence pointing to O.J.'s guilt. This evidence included such details as O.J.'s history of stalking and beating his ex-wife, and the blood from both victims on his socks and in his car and at his house and so on. When Marcia Clark's opponent, attorney Johnny Cochran, won the trial in spite of all the damning evidence against O.J. Simpson, it finally demonstrated to the world that money, and sometimes race by association, really does tilt the scales of justice in favor of the wealthy. Johnny Cochran's confounding triumph over truth and against justice forced many narrow-minded deniers to finally concede that trial outcomes are not always determined by evidence alone, and many citizens realized for the first time that rumors of brazen injustices were in fact accurate narratives by victims of oppression, and not, after all, fairy tales conjured up in the minds of paranoid malcontents. After the not guilty verdict, O.J. Simpson's attorney, Johnny Cochran, was quoted to have said, quote, 95% of my job was done before the trial even started, before any testimony, before any evidence was presented to a jury. 95% of the job was done. What he meant by that, of course, was that he had so carefully pre-screened and pre-selected his jury that there was no way he could lose the case, so long as he provided his predisposed jurors with some rationale, no matter how dubious, for disregarding Marcia Clark's abundance of evidence. And of course, the pretext the jury adopted for embracing the not guilty verdict was that the bloody glove apparently didn't fit O.J. Simpson. Whether it had shrunk, or whether O.J. had taken a spoonful of salt to make his hand retain water and puff up like a balloon, or whether the gloves were never his to begin with, we will never know. But in spite of the two victims' blood spattered all over the place wherever O.J. had been, in his car, on his socks, and in his house, etc., there was still the not guilty verdict. By jurors who had by then been made aware of the obscure pretexts for rationalizing, at least in their own minds, their not guilty verdict. Other cases of jury consultant orchestrated miscarriages of justice abound, such as the infamous Rodney King beating trial and the Kelly Thomas beating trial, which we covered previously, and the Lorena Bobbitt trial, where an angry wife threw a tantrum and chopped off her husband's penis, and was later acquitted by a sympathetic jury, and the William Kennedy Smith rape trial, where the jury seemed to be so enchanted by the glamour of the various Kennedys in attendance at the trial that after the jurors declared him not guilty, some of them actually lined up to acquire autographs from William Kennedy Smith's various Kennedy relatives. It should be noted here that sometimes those with borderline personality disorder and their followers, who might not be overtly bullies themselves, love to align themselves with beauty, glamour, wealth, and power, irregardless of any moral scruples involved. And it has been proven that it is very difficult for an attorney to successfully prosecute certain individuals who are very attractive or powerful or famous, such as a Kennedy or even a member of law enforcement. So for a tenacious and persistent attorney, it is not much of a problem to find and bring together 12 borderline personalities and their followers into a jury to win his desired verdict. In Part 3, to illustrate the typical behavior of individuals interacting with each other within a group, such as what might be observed in a jury deliberation room, I am going to make reference to the characters in the movie The Wizard of Oz. In that story, we have the wizard and the scarecrow without a brain, the Tin Man without a heart, and the Cowardly Lion who has no courage.